Welcome, everyone. Thank you so much for joining us today. This webinar is Nuts and Bolts of Standby Guardianship, a substantive training on standby guardianship as a tool in future planning. My name is Jeannie Ortiz, and I am a Senior Program Manager at Pro Bono Net. So Pro Bono Net is a national nonprofit organization based in New York City, and we leverage technology to expand legal help and access to justice, and also facilitate resource sharing and trainings to legal aid and pro bono attorneys. And I've had the pleasure of working with Carla Johnson at Mobilization for Justice to organize a series of webinars on kinship law this year. And this is the first one that we're bringing to you today. So everyone will be muted by default, but we certainly encourage your questions, which you can enter in the questions box you see on your GoToWebinar control panel. And if you registered before today and submitted a question to panelists when registering, we have also sent those questions to the speakers for their review and consideration. Okay, so this webinar is being recorded, and all materials will be posted to the NYC Pro Bono Center, which is an online hub with resources for pro bono and legal aid advocates across New York City. We've also included the link here, and this is where you can also check for upcoming events and trainings. We'll post those there. You'll see on your GoToWebinar control panel that we've also attached the webinar materials as well as additional resources. So you should be able to download those at your convenience. And that, with that said, I'll hand it over to Carla, who has organized a great group of experts on today's topic. Carla?
Thank you, Jeannie, and good afternoon, everyone. You are in for a treat in learning a bit more about standby guardianship. I want to, at the very outset, thank our group of panelists, and just very briefly want to give an introduction for each of them. Randy Redkin is the director and founder of Legal Health, a division of the New York Legal Assistance Group, or NILAG. Legal Health is the country's largest medical legal partnership, and prior to NILAG, Ms. Redkin served as Director of Legal Services for the Gay Men's Health Crisis, the nation's oldest and largest organization serving people with HIV/AIDS. Ms. Redkin has served as a staff attorney with New York Lawyers for Public Interest, as well as for VOLS, or Volunteers of Legal Services, where she established VOLS Immigrants' Rights Project. She's the founder of the New York Immigration Coalition and the National Cancer Legal Services Network. She's also the co-founder of New York State Standby Guardianship Law and helped spearhead the expansion of the laws to assist immigrant families most recently. Ms. Redkin is a former member of the New York City Bar Association's Ethics Committee and is a frequent speaker on ethics. So thank you, Randy, for being with us today.
My pleasure.
And Caroline Bursak is one of our two panelists from the Family Center. She's currently the Director of Legal Services for the Family Center, which is a multidisciplinary New York City nonprofit organization. At the Family Center, Caroline leads the Legal Wellness Institute, which provides accessible, holistic legal services to low-income families here in New York City who are impacted by serious illness and life-limiting disability. Caroline has been providing legal services to the Family Center for nearly 15 years now and has been the director of the Legal Wellness Institute since 2019. Caroline received her bachelor's degree in both community health and public policy from Brown University and her JD from NYU Law School, or School of Law, rather. Caroline previously has professional experience in the healthcare research and litigation space, and she regularly presents on legal issues affecting those with serious illness and disabilities, as well as social determinants of health and health-harming legal related issues. Lauren Groach is the Assistant Director of Legal Services for the Family Center, and she oversees the Family Center's Legal Wellness Institute as well. And prior to working with the Family Center, Lauren has Well, I'm sorry, Lauren's has worn a couple hats with the Family Center. She's also a staff attorney and senior staff attorney before advancing to being assistant director with the Family Center. And just a bit of her background, Lauren received her bachelor's with distinction from the University of Virginia, as well as her JD from NYU School of Law, where she was named a Herman Briggs Health Policy Scholar and Robert McKay Scholar. Thank you all three for joining us today. Again, I feel like we are very much in for a treat and learning more about this very critical space for families. I'm going to hand it over to Randy. I'm sorry at this point.
Great. Well, thank you, Carla and Jean. Really appreciate a chance to present here today and also to present with my fellow colleagues. You know, as you mentioned, if you want to go to the first slide, that'd be great. Jean. Great. As you mentioned about standby guardianship and being a really important and critical tool, it really is, and I really have had the fortune of sort of watching its progression, if you will, throughout the years, first in the health context and then in immigration, and we'll go into that in detail. So really, what is it? And it is really a tool for parents who either have chronic, progressive, or terminal illness, or parents who are at risk of immigration-related separation, and that's a term we'll describe a bit later, who have minor children, and if they have concerns about how to plan for these children in the event that the parent can't care for them. And so today we'll talk about you know, how it works, how it allows certain parents, and parents' definition is fairly expansive. It's parents, custodians, guardians, or other primary caretakers of children to plan for future care and custody of their children. And so we'll go over a little bit of the history, although I think we've touched upon some already. How you actually designate or petition for someone to become a standby guardian, the benefits and limitations of guardianship, and also other tools that may be available to meet parents' planning needs. And I know that there is time as well at the end for questions, which we certainly look forward to. So with that, if you turn to the next slide, that'd be great. Okay, so what is this standby guardianship? And if you think about the word, what does it stand by? That always helps to explain it. It's somebody who is actually standing by, waiting. So a standby guardianship is really a means for the children's parents, and again, that sort of expansive definition of parent, guardian, custodian, and primary caretaker, to plan in advance for the future care and custody of their children, again, in the context of health or immigration enforcement. And the best thing about this is that really it allows planning without relinquishing parental rights. And as you'll hear, it really provides comfort for parents who might be in a situation, either because of health or immigration, where they really feel that this is the most important thing for them to do, is to just make a plan for a person they trust. So the parent's incapacity, debilitation, death, or administrative separation triggers the standby guardian's temporary authority. So trigger is, again, a word that's sort of interesting. And if you go back to standby, they're standing by until this triggering event. The law is found under Section 1726 of the Surrogate Courts Procedure Act. And the family court and the surrogate court both have jurisdiction over standby. But I think what you'll hear today is most people do file in family court and not much in surrogate, but we could talk about that as well. Next slide, please. Again, a little bit of the history, but it's interesting. It was initially passed back in 1992 to enable parents who had HIV or AIDS or another serious illness to designate a person to serve as guardian for their children for 60 days from the time of their incapacity disability, and consent or death. And then recently it was expanded again in terms of the health context. In response to COVID-19, it was temporarily amended by executive order to allow for healthcare workers and others to designate standby guardian for the same purpose. Of course, this executive order has expired with all the other sort of executive orders under the pandemic. Next slide, please. On June 2018, it was amended to enable persons subject to risk of immigration enforcement to make use of the standby guardianship. And I just want to note that this was something that I worked on with people from the Family Center. So again, it's great that we're all doing this together. And this was really because of what was happening under the Trump administration and the fear that so many immigrants had about what would be happening to them and the imminent possible immigration enforcement. So under the immigration context, for purposes of standby, immigration enforcement that interferes with a parent's ability to care for their child, and it's referred to as administrative separation. And it's defined specifically in relation to immigration, and it does include anything like incarceration, criminal offenses, military deployment, or other circumstances in which a parent may be separated from their children or fear that they might be. Other planning tools can be used for that. And I know people often ask, oh, can we use it if I'm in this situation or that situation? But you'll see that it is limited. Next slide, please. So how do we do it? How do you create or make a standby guardianship? There are two ways of doing it. You can either do it by judicial appointment or by a written designation. Let me talk very briefly about judicial appointment. And just to know, we noted at the bottom, this is rarely used. And if we have time, we can describe situations where we have used this judicial appointment. But basically, under the section of SCPA, it provides an option for the parent to petition for the court appointment of a standby guardian. So basically, and primary caretakers with no official legal authority must prove standing in order to pursue this portion of the act. Again, the petitioner must have a progressively chronic illness, an irreversible fatal illness, or be at risk for administrative separation, and they must state this in the petition. And judicial appointment standby guardians can commence upon any of the following. And again, it's the same categories: separation, incapacity, death, or consent. Again, I state that this is rarely used, but it is an option when people feel that they need to have the appointment done before anything happens, before that triggering event. And as you'll see in the next slide, the other way to do it without sort of going to court and getting everything settled first is to really write a written designation. And that's the form that we'll spend most of our time talking about. And it provides a section of the law that you see on the screen provides the requirements for just a written designation. And that's the tool we're referring to. And it provides sample language. And basically, the designation should include a statement that the parent believes that the standby guardian would serve the best interests of the child. And anybody who practices in family law is very familiar with best interests of the child. Designation can provide that the standby guardian's authority extends to the person and/or property of the children. The parent may designate an alternate standby in case the primary cannot serve or is unwilling. And the designation must be signed by the parent in the presence of two witnesses who are at least 18 years old. And if parent is physically unable to sign, another person can sign on the behalf of the parent and the two witnesses. and the standby cannot be one of the two witnesses. And if you do healthcare proxies or powers of attorney, especially under the new power of attorney law, you'll know about the fact that somebody else can sign on someone's behalf. Again, many times we're dealing with people who are seriously or chronically ill and don't have the physical capacity to sign. Important, signed by the standby, it does not have to be at the same time as the parent signs. And just one note before I turn it over, I believe, to my colleagues. The next slide is that, well, this is New York law. There's about 29 states that also have some form of standby. So this is something that people around the country have recognized as an important tool. I think, Carolina, you're up next. Oh, Lauren, sorry.
Thanks, Randy. Thank you. And I'm really glad you mentioned that other states also have standby laws, because one of the things we're going to talk about on this slide is what happens when you want to, a parent wants to name a standby guardian who does not live in New York. So, of course, the primary consideration that a parent might have, and I'm using parent broadly again, in choosing a standby guardian is, who do I want to take care of my children if something should happen to me? But there's some other things that the parent should think about as well. Most of these considerations have to do with the requirements for actually being appointed a guardian, right? So you can name anybody you want in the standby guardianship designation, nobody's checking, until they have to go to court to be appointed. And at that point, these considerations become very important. So you can only appoint an adult, somebody over the age of 18. The criminal history is important insofar as felony convictions are a bar to acting as a guardian, but also non-felony convictions. A criminal history check is typically performed when the guardian goes to, when the standby guardian goes to court to be appointed, to be confirmed. They'll be fingerprinted. And the court will also be considering, you know, in that sort of best interest evaluation that they do. They're going to be considering, you know, if you have a long history of misdemeanors, that might impact on the court's opinion of your ability to act in the child's best interest. That could be a problem, right? Similarly, with child abuse and neglect, domestic violence history, the court checks the statewide central register of child abuse and maltreatment. They ask for an address history for 20 years. Most courts ask for everybody in the guardian, everybody in the guardian's home. They ask for that. That address history. They want to see SCR history or child abuse neglect history, not legally a bar, but again, something the court considers under the best interest standard. What is the person's relationship with the child? Is the child familiar with them? This is especially important for older children because the court will ask the child. The court we'll talk about later how the court asks the child, but the court will want to know what does the child want, with whom does the child prefer to live. And then where the standby guardian lives. Sometimes we'll have folks say, I would really like to appoint my sister. She lives in Pennsylvania. My next question is always, well, what is the plan? Is the plan for the children to move to Pennsylvania? Because if that's the case, you know, this standby guardianship designation is a creature of New York state law. It might be worthwhile exploring whether the state that the children are going to go to has a standby guardianship law that might be a more appropriate or an appropriate adjunct to doing a New York standby guardianship designation. Or is the person going to move into your home with the children, right? You want people to really think through what is the plan, because you want to be pointing them to the right tools. Okay, next slide. I want to talk about some additional safeguards or best practices when completing a written designation of standby guardian. If both the parent and the guardian, because they both need to sign a standby, are not English speakers, it's best to translate the standby guardianship and attach an affidavit of translation to the standby guardianship designation, to the written designation. As with all advance directives, we want to speak to the parent alone about their wishes, especially not with the standby guardian in the room, but ideally it would be you, the parent or guardian or custodian, and an interpreter if you need one, and nobody else. we don't want to have competing documents like with all advance directives. So you want to find out, have they completed a standby guardianship designation before, or have they named a guardian in a will, nominated a guardian in a will. You don't want, even though they're two different documents, you don't want them to disagree. And when there's another parent, and that parent is not the person that your client or the parent wants to name as their standby guardian, you want to find out what is the relationship with that parent. Why are they not selected? Very frequently, it's somebody who's been absent. They don't have much of a relationship with the child. That's fine. Ideally, you would have some sort of a sense that that person agrees. If that's not the case, and there's and we know there's going to be some conflict, or there's likely to be some conflict when this ends up in court for appointment of the guardian. It's a nice thing to have, and we really recommend that the written designation have some language in it about why the legal parent is not the person who the parent chose as their standby, why it wouldn't be in the child's best interest or the children's best interest to be with that person. Next slide. So we're going to talk a little bit about what happens when one of the triggering events occurs. So you've done your written designation of standby guardian, then unfortunately something has happened, and now the standby guardian's authority needs to take effect. How does that happen? So in the context of health, we have these three triggering events. They are death, incapacity, and incapacity in the context of standby guardianship law means mental incapacity, and then debilitation, which again in this context means physical debilitation, and consent. So sort of the simplest one is death. The standby guardian needs to get a copy of the parent's death certificate. Could also be a funeral home receipt or another document indicating the parent's death. Really ideal to get the parent's death certificate, and that in combination with the duly executed designation of standby guardian sort of begins and serves as evidence of the standby guardian's authority to act as guardian. And under all of these triggering events, that authority lasts for 60 days. Within that 60-day period, the standby guardian needs to go to court and petition to be appointed as the permanent guardian of the child. That can be family court or surrogate's court. We'll talk about that a little bit later. So the second triggering event, it doesn't have to be that the parent has died. There are other circumstances that are dictated by health in which the parent might no longer be able to care for their child in the way that they want to. One of those would be the mental incapacity of the parent. The statute defines this as chronic and substantial inability to understand the nature and consequences of decisions concerning the care of the child as a result of mental impairment. And of course, the consequent inability to care for the child. A medical provider needs to sign a determination of incapacity. That again gets sort of combined with the designation of standby guardian to serve as evidence that the standby guardian's authority has been triggered. The 60 days have begun. Sometimes the parent is with it. They have mental capacity, but because of physical debilitation, they're not able to care for the child anymore. Maybe they're hospitalized, maybe they're bedbound, and they need somebody to be going to doctor's appointments and school meetings, things like that with the child. The statute defines debilitation as a chronic and substantial, so not just for today, inability to care for the dependent child as a result of progressively chronic or irreversibly fatal illness or physically debilitating illness, just like how the statute defines the qualifying illnesses to be able to use the standby guardianship designations, disease or injury, illness, disease or injury. In the context of the parent still having mental capacity, you need a certification by a medical provider of debilitation, which is similar in form to the certificate of incapacity, and you need written consent from the parent.
I had a really quick question, if I might, Lauren, and I meant to ask it on the prior slide, but it kind of relates here in terms of the documentation. that should be provided in those 60 days when the standby guardian is going to court, just in relation to a custodial parent or another biological parent, and sort of evidencing desires of the parent, in this case's desire to not have that individual be the guardian or the caregiver moving forward. I'm wondering if any sort of evidence as far as beyond death certificates, but just if there is a history of domestic violence or any other documentation as far as issues with that prior parent, if that is documentation that you would advise be included, as well as maybe a copy of the birth certificate of the subject child or children.
So those are documents that we wouldn't necessarily say the standby guardian should be toting around with them to show to show evidence of their authority during this 60-day period, but they are the kinds of documents that we would really want the parent to make available to the standby guardian to help give context. Of course, things that relate to the child's Medicaid card, the child's birth certificate, the child's passport, all of those things, really helpful if the parent can let the standby guardian know where they can find them. Evidence of this gets into a larger issue, right? But if the parent has a life insurance policy or a bank account that is in the child's name, right, also helpful for the standby guardian to know where those are, that they exist, things like that. But rules of evidence will apply in family court when the standby guardian goes to court, and right. So you can't just show up with a letter from the parent that says, I really don't want dad to be or mom to be the person with custody of the child. Yeah.
No need to go down that windy road of a can of worms that might open, but just curious in terms of documentation. Sorry to cut you off.
Yeah, that's really helpful. That's great. Thanks, Carla. Okay, next slide. We'll talk about immigration, the immigration trigger. Oh, no. Not yet. Okay, so we'll go into incapacity and debilitation in a little bit more detail. So just some more details about the incapacity and debilitation certificates. They need to be from the attending physician and contain some specific language. They need to be in writing. And the consent form that the parent signs in the case of physical debilitation also needs to be witnessed by 2 witnesses. The standby guardian cannot be one of the witnesses. In the case of physical debilitation where the parent still has capacity, we sometimes recommend that the parent, rather than triggering the standby guardianship and having their 60 days start to run, that they consider whether other options like a designation of person-parental relation, we'll talk about that later, could fill that gap for them so that they retain the ability to use the designation of standby guardian if they should pass away. Okay, next slide. So let's talk about the immigration. So immigration enforcement for the purposes of the standby guardianship law is, again, as Randy said, we talk about that as administrative separation. It can include a wide variety of things, so deportation, arrest for immigration reasons, detention, or receipt of an official communication by a government authority regarding immigration enforcement that gives a person reasonable notice that the care and supervision of the child will be interrupted. So, for example, something that says to report somewhere, right, because you are going to be detained or deported. And then the statute has pretty specific standards for what constitutes acceptable documentation that an administrative separation has occurred, and we would refer folks to the statute to make sure that they get it exactly right when they figure out what kind of piece of paper they need for the specific kind of administrative separation that's occurred in their case. Next slide. So at the time of the triggering event, regardless of what the triggering event is, the standby guardian needs to make sure that they have a verified copy of the designation form that's been signed by them and the parent. Again, it doesn't need to be signed by the parent and the guardian and the designated standby guardian at the same time, but it should have been signed by both parties. And then they need the documentation. We talked about all of the different forms on the preceding slides, that whatever the condition the triggering condition is, in their case, has occurred. And then, so those are the two documents that they use to show evidence of their authority, which lasts for 60 days. They need to go to court. If they don't go to court within those 60 days, their authority to act as guardian will cease after the 60 days. But if they then go to court and file, their authority will recommence. If they go to court and file within the 60 days, their authority will continue until an order, either an order appointing them as the permanent guardian or a temporary guardian, or an order saying, you know, they no dice, the children are going with their absent parent, something like that, or with another person has been made. And I think I'm going to turn it over now to Caroline.
Thank you. Can we go to the next slide, please? So, right, as Lauren mentioned, you know, when the standby guardianship gets triggered, it automatically comes with 60 days of authority for that guardian, the standby guardian, to basically act as that child's guardian. So if decisions need to get made during that time, they can present the designation of standby guardian along with documentation of the triggering event to the school, the doctor, whoever it is who, you know, needs to see some proof that they do in fact have authority over this child. And that continues again for 60 days. And during that time, they are supposed to petition the court for their appointment as permanent guardian of that child, which is, you know, that's one of the great benefits of the standby guardianship law, this automatic 60 days of authority. Of course, 60 days isn't all that long. And so it doesn't always happen within 60 days. As you know, as Lauren mentioned, the statute does specify that if they petition the court after the 60 days, their sort of authority will recommence, but there will be a period of time in which, technically speaking, it's possible that no one will have decision-making authority, you know, over that child. But just to be clear, it's not like on the 60th day, somebody comes and takes that child out of their living situation if they are somewhere safe, if they are doing fine, you know, nothing really happens. But if, again, a decision needs to get made, consent to medical treatment, this issue with the school, when the time comes, there is sort of no way to prove that this person actually has authority over that child if the 60 days has lapsed. So ideally, a petition would get filed within the 60 days. That petition process is, you know, relatively similar to a regular petition for appointment as guardian when there has been no designation, with a few key differences. The petition needs to meet the same requirements in terms of the, you know, what you allege in the petition, what the contents are. Surrogates Court Procedure Act 1704 spells out what needs to be included. There are also forms from both the family and surrogates court that generally lay out what you need to include, although you may need to add a paragraph discussing the designation of standby guardian to the court forms. You want to definitely attach that verified copy of the designation of standby guardian to the petition, as well as the documentation that the triggering event has occurred. So the parent's death certificate or the physician's determination of incapacity or debilitation and parent's consent, etc. Those go to the court along with the petition. And then the question of which court do you file in, right? Because both the family court and the surrogates court have jurisdiction over guardianship in New York. Most often, as Randy says, these go to the family court, which has the jurisdiction over appointing guardians of children's person. Family court is often a little bit easier to navigate, especially for people who might be pro se. They certainly see a lot of guardianship petitions, so they know how to handle these. But again, they only have jurisdiction over guardian of the person, whereas the surrogates court has technically jurisdiction over appointing guardians of both that child's person and property. Just very briefly, guardianship of the person is what we probably think of most of the time when we think about guardianship. It's pretty similar to the automatic authority that parents have over their children. So the ability to make decisions about, you know, healthcare and medical treatment, educational decisions, consenting to children participating, you know, in various activities, or, you know, what decisions about what kind of religious observances the child partakes in, all those kinds of decisions about, you know, raising a child that parents automatically get to make. That's generally what is included within the guardianship authority as well. Guardian of the person, excuse me. Guardian of the property comes into play if that child either has or stands to get soon certain identified assets or property. So, if they are if a parent has passed away and they may be inheriting significant, sums of money, bank accounts, investment assets, real estate, things like that. If there's been a lawsuit and the child has, a settlement or an award coming to them, then a guardian of the property may need to be appointed in order to sort of safeguard and manage those assets until the child turns 18, becomes an adult, and can do it themselves. Many children do not need a guardian of the property. So it's only if there is identified property that is the child's or will soon be the child's that becomes necessary. And I will note that certain types of benefits that are frequent, so like Social Security survivors benefits that a child may get from a parent who's passed away, supplemental security income that a disabled child may receive, cash assistance benefits, SNAP, food stamps. None of those require guardian of the property to manage. They're all subject to their own rules about how those benefits get used on behalf of a child by the appropriate person. But, things like life insurance policies, again, bank accounts, real property, things like that, there might need to be a guardian of the property appointed at that point, and that would involve petitioning the surrogates court. So once that petition is filed with the court, again, Lauren talked about some of this in making sure we designate an appropriate person. The court is going to require information about, both parents, if both parents are still living, or, at least the other living parent, if one parent has already passed away. And the court will usually require, service of the summons and petition on any parent, or if there's been a legal guardian or custodian previously appointed for that child, so that they have noticed that someone is now petitioning for guardianship of, of this child. And service on this other parent or other, guardian custodian can be waived in only very, very limited circumstances. And I'm sorry, I forgot to say next slide. So please go to the next slide. Thank you very much. Okay. So that other parent, if there is one, is likely going to be notified that someone is petitioning for guardianship. I will make a quick note here. This gets very into the nitty-gritty of sort of family law. I know that many of you are not necessarily family law practitioners and may have no particular plans to, ever handle this aspect of standby guardianship. That's fine, but I still think it's important to have a good context and understanding for what comes next in order to properly advise someone who might be considering doing a designation of standby guardian. So we'll go into this a little bit, but right, that other parent is likely going to be notified. I'll say a quick note here about there is a little bit of a difference in the law between how some fathers are treated, only because of biology. It is not uncommon for there to be birth certificates that name a mother, but not necessarily a father. So, if there's a father who is not on the birth certificate and has not, there's not been an order of paternity or an acknowledgement of paternity filed, but they've been involved in the child's life in some way, potentially, or at least, their identity is known. It gets a little bit complicated there. There are some situations in which the court may not require service, but in general, courts err on the side of, of notifying parents, even if they're not technically legal parents, that someone is petitioning for guardianship of their child. So you have to sort of assume that that's going to be part of the process. If the other parent disagrees with this person's appointment as guardian, then they can contest the proceeding. And parents have a greater right to guardianship or custody of their own child than any person who is a non-parent does. That's sort of a constitutional right that's been recognized by the Supreme Court. So if there is another parent out there who shows up in court and says, no, I don't want this person to be guardian, that's my child and they should be with me, then that non-parent, the standby guardian, is going to have to demonstrate to the court that there are extraordinary circumstances that would even justify the court even considering awarding guardianship to someone other than the parent. It's kind of seen as a standing hurdle they have to get over before they can even move on with the rest of the guardianship proceeding. If there's another parent, but they agree that this is the right plan, that this child should go with the standby guardian, they can consent, and there is a court form they can sign indicating that consent, which is great. If they will do that, they can also just get served and not show up in court. And the judge may give them another opportunity to show up, but if they don't do anything, then it's generally the petition will proceed as uncontested. Some courts may also require service on other people in the child's life. Most often it's relatives, sometimes it's adult siblings, grandparents, aunts, or uncles. There are some courts that have a rule where sort of anyone in the same category as the person petitioning has to get served. So if it's an aunt who is the standby guardian is petitioning for appointment as guardian, the court may require that she serve all the other aunts and uncles or something like that. If that's really up to the individual judge and the individual court what their rules are. It's not required by statute. As Lauren mentioned, the court is going to require the guardian and all the adults in their home come in for fingerprinting to check for criminal histories. They will also require that they provide their 28 years of their address history in order to check the statewide central registry of child abuse and maltreatment. They'll also check registries of orders of protection as well for the guardian. Again, other than having the guardian themselves having a felony history, none of those are automatic bars to the guardian's appointment, but they are things the court is going to consider in determining whether this particular guardianship, this home, this person, is what is in the child's best interest. Is this the best person to care for this child? Are they an appropriate guardian? The court may also order, it's called a court-ordered investigation of the guardian in their home. It's usually done by either the Department of Probation or the local child welfare agency. Usually involves going to the home, looking around, does it seem safe, who else lives there, interviewing people who live in the home, that kind of thing, and that gets reported back to the court for the court to consider in evaluating the child's best interests. Children will almost always be appointed their own attorney. It's called an attorney for the child, and that person's job is to represent that child and what their wishes are, to advocate, for what they want. So if the child wants to be with the standby guardian, that's great. If the child does not want to be with the standby guardian, then there's going to be an attorney who is advocating against the standby guardian's petition, in that case. The time frame and the timeline for all of this can vary significantly depending on, the family situation, whether somebody contests or not, and just also based on what court you happen to be in and what their scheduling is like. It can, I've had a few of these that go through basically on the first appearance. It hasn't happened for a long time, but it is technically possible if they have gone in for their fingerprinting and nothing comes up and no one contests. And especially if the child is maybe very young or something and the court doesn't feel an attorney is necessary. Very rare. I've also had these take literally years and years to complete. So it will be somewhere in between those two. And hopefully, I think most commonly these proceedings take a few months. And again, unless there's a parent who's really contesting, in which case it gets much more complicated. Next slide, please. So the designation of standby guardian pursuant to the section 1726 of the Surrogates Court Procedure Act is not the only method that allows a parent to plan for their child. I think most people are familiar with right last wills, and as part of a will, parents can nominate a person to be the guardian of the person and property of their child. And there are some benefits and some drawbacks as compared to the designation of standby guardian when you think about using a will versus the standby guardianship designation. So one of the sort of benefits of a will is that any parent can do this, right? It doesn't have to be a parent who has a serious health condition or fear of, administrative or immigration separation from their child. It can be any parent who wants to plan for, any kind of event that may occur, or any kind of unanticipated death that might occur. The other, thing is that wills can do much more, right, than a designation of standby guardian can do. Wills can plan for the parents, assets and distribute them in whatever way the parent wants to distribute them. That can involve financial planning for children in ways that are more sophisticated, using trusts or UTMA accounts or other things like that if you want to leave property either to a child or to be used for that child's benefit. So, it might make sense. A parent might need a will anyway. And so it might make sense to include a designation of a guardian in that will, either in addition to or instead of a designation of standby guardian, if that's the case. There are some limitations of nominating a guardian via will rather than designation of standby guardian. The first is that, right, wills only come into play if that parent has died, right? They don't, if that parent becomes incapacitated or debilitated or, you know, deported or other kind of immigration separation, right? That will is not going to be of any use at that point. It does not give that standby guardian or that guardian any authority. The other limitation is that even if that parent, you know, does pass away, there is no automatic, you know, 60 days or otherwise authority for a person who's been nominated as a guardian in a will. You know, as opposed to the designation of standby guardian, the triggering event occurs, that standby guardian can act as guardian immediately, basically once they receive that documentation. Not so with the will. The will has to get submitted to court, probated, and the court has to take action to, you know, approve the guardianship before that person has any authority, and that can take quite a long time for that to occur. So there will be a period of time in which, you know, perhaps nobody has authority again over that child to deal with things that come up during the interim. Wills are also much more, you know, complex to draft and to execute and, you know, to admit to probate. So, you know, if a will is not strictly necessary for other reasons, standby guardianship designation might make more sense for that parent. Again, it's not impossible that someone could do both a will and a standby guardianship designation. They are not at all mutually exclusive, but you do want to, you know, talk to the client, make sure that the documents they have are in agreement, because if there's, you know, a designation of standby guardianship naming one person and then a will nominating somebody else as guardian for the, you know, the same child, there's going to be some confusion, possibly some contest between the two people. The law, you know, depending on the order they were completed in, the law may or may not sort of be clear about which one carries. It's so you want to make sure that this person, they have a cohesive plan in place with all their documentation as to what happens with that child. Next slide, please. One other tool that's really important to know that can be very, very helpful to parents who want to, you know, plan for certain circumstances for the care of their child is the designation of person in parental relation, which is the real name and is authorized by statute in New York. It's a general obligations law that specifically authorized it, but it's also referenced in the public health and the education laws. And the statute allows a parent to authorize another adult to make routine medical and educational decisions for a minor child. So there is some overlap between the designation of person in parental relation and the designation of standby guardian, but there are also some key differences. One of those differences is that for designation of person in parental relation, the statute does not specifically define parent the way that the standby guardianship law does, where they specifically make clear that a legal guardian, a legal custodian, or a primary caretaker of the child can use a designation of standby guardianship to plan for the child. Designation of person in parental relation just says parent and doesn't define it, so may be interpreted as being limited to someone who is only an actual, you know, legal parent of that child to use that designation. The designation of person in parental relation statute also specifically requires the consent of another parent if there is an order that gives both parents like joint custody or gives both parents decision-making authority over health and education decisions. Whereas the standby guardianship law is pretty silent as to whether you need the other parent's agreement in any circumstance, although we talked about how the court will look into that later. The designee and a person in parental relation also cannot make major medical decisions. That's one of the major, the significant differences between the authority a guardian or a person with guardianship authority has versus someone designated through this designation of person in parental relation. And major medical decisions includes things like non-emergency surgeries, major procedures requiring the use of anesthesia, electroconvulsive therapy, or withdrawal of life-sustaining treatments. But they can consent to many kinds of routine medical care, and they can make most educational decisions for that child. One other really big difference between the designation of person in parental relation and the designation of standby guardian is that a designation of person in parental relation terminates immediately upon the parent's death or incapacity. So obviously it cannot be used to plan for those two particular situations. A designation of standby guardianship can be used to plan for those events. Some of the benefits of this form: it's a very simple form for the parent to complete. Again, there is no court that needs to be involved in giving the designee authority, and it can be useful for all kinds of sort of temporary caregiving arrangements. Depending on how you complete the designation form, the authority can be given to the designee either immediately upon the form's execution, it can be given on a specified date that's written into the form, or the designee's authority can commence upon a triggering event that is specified in the designation. And so, for example, a parent who might be traveling and not taking their child with them, wants to leave that child with someone else, can use a designation of person in parental relation to give that other person, the ability to make general decisions for their child while they are away, can use the specific dates they're going to be away in the designation. Or a parent who has an illness or a condition that may require them to be hospitalized on an inpatient basis from time to time can create a designation that says it becomes effective in the event of their inpatient hospitalization or something like that. It can be personalized for a lot of circumstances. Under the law, a designee's authority pursuant to one of these designations can last only up to 12 months. But if the parent wants this, the authority to continue beyond that, they can just execute a new form, and that will extend the designee's authority. If the authority is going to last for more than a month or could last for more than a month, the form just needs to be notarized when the parent signs it as well. And I believe that is our last slide, and it is time for questions and answers. Hopefully answers, questions and hopefully answers.
So we may have a few questions trickle in, but I do know we received a few questions in advance that I wanted to just check in with folks on and see if they have any answers to questions. Just bear with me 1 second. Let's see.
Yes, so we have you have a few on your questions, and we also have the ones that registrants asked when they signed up for the webinar.
Okay, I don't know, Jeannie, if you have a preference in terms of order. I didn't know if a couple more had come in, and I'm just trying to scroll through to find them. So I don't know if, let's see. Oh, I have them. Okay. One of our participants asked ahead of time if there could be some guidance in the process in terms of if there is a victim of domestic violence. I'm assuming that might be pertaining to the parent who might be facing incapacity. I'm not sure if it could also be referring to other individuals involved. If so, what advice do you have? Or maybe just an overlay of there being a domestic violence case. I don't know if it would be active or just recent.
I mean, in the context, oh, go ahead.
Go ahead, Lauren.
I was going to say, in the context of, a conflict between the designated standby guardian and, say, a non-custodial parent who doesn't agree that the standby guardian should be named or should be confirmed. Sorry. It would go to extraordinary circumstances, right? Any facts relating to domestic violence, child abuse and maltreatment, all of that would go to the question of extraordinary circumstances. And then if that hurdle is passed and the court gets to the question of with whom should the child live, what's in the child's best interest, then it also goes to best interests.
Right. And I will just add that I think, if I think that is probably the most common situation in which we see domestic violence playing out here is that, right, there perhaps is a non-custodial parent who has been violent in the past towards either the other parent, or the child. If you are going the route of a written designation, it is probably important to include that in the written designation, that is why, that this parent is naming someone other than the child's, other parent as standby guardian. And sort of like the question Carla asked earlier, because when the standby guardianship gets triggered, that parent may not be able to participate in providing information about, what the situation that happened in the past. It is certainly ideal if the person who is designated as standby guardianship has at least, some knowledge about what transpired in the past. If there is documentation like police, reports, orders of protection, things like that, that they know, at least that it exists and where to find it. Again, right, it is going to be subject to the rules of evidence. So you've got to make sure that, you may need to do discovery and get certified, copies of these things, etc. But knowing that they exist, right, can be very, very helpful as well.
Yeah, and just one practical point is, if you look at the form and where you're supposed to describe why you want the standby and why you don't want, say, the custodial parent in this, or the non-custodial parent in this situation, who there might have been instances of domestic violence, just write as much as you want. I mean, to really describe the situation. I mean, it's really important. This is where you're really talking about the wishes for the parent, as well as what she doesn't or he doesn't want. So it's your opportunity to talk about incidents of domestic, that there has been domestic violence, etc.
One other question we have is, how does one address individuals with changing capacity or varying mental ability, if it varies, I guess, by day or hour, and an example such as sundowning? So
yeah, a really, really great question, and we could talk all day about capacity and capacity assessments, but we have cases like this a lot, and what we usually do is try and speak to family members, social workers, people involved in the person's care and the person themselves about when they're at their best, right? Is it right before they get their pain medication? Is it in the morning? And trying to, just trying a couple of different times. Sometimes we've, with a person's consent, of course, providers are able to, hold off on giving a medication until we can get there, things like that, to try and help a person sort of be at their most lucid, at the height of their capacity when they're talking to us. In those cases, it's extra important that the person does not have any influencing people, any family members around them when we speak to them. You want to, obviously, if you're the attorney helping somebody, execute this form, you want them to be, you want to have taken really good notes about capacity and the capacity assessment that you've done. And you want to be sure that there's no appearance of undue influence.
I wonder if the question can also be answered or is asked in the respect of what happens if you have a parent who's losing capacity but then gains capacity, losing capacity, gains capacity. How does the standby relate? Yeah. And remember, with standby, nobody loses parental control. You're co-parenting, really, if you think about it. But it is an interesting question about, when does the 60 days begin? You think it's about to begin, but remember, there's determinations that a physician has to make for incapacity, or the parent has to consent. So until that happens, I think it's sort of this flexible situation.
Right. Yeah.
So I know we're 1 minute away from ending, Carla, but we have like six to seven other questions coming in. So we can send those to the panelists directly, or if you want, just to use the last 1 or 2 minutes to go over a few of them.
Yeah, I will leave it to you to be the judge. If you think there are some that can quickly be answered, and then maybe the remaining questions can be sent out to panelists, and if folks really have burning questions, hopefully they can also reach out.
Sure. But one of the question is an order issued in one state applicable in another state?
And I think I'll try to answer this briefly. If there's an order of appointing a guardian, the answer is sort of generally yes, that is given full faith and credit by other states. There is also, in some states that have adopted the Uniform Child Custody Jurisdiction and Enforcement Act, there may be a method for the guardian to, register a New York State order of guardianship with the new state. If we're talking about an order appointing a judicial appointment of a standby guardian, that might get a little bit more complicated because there's not necessarily always an equivalent to that in the other state.
Great. And then I think the last question we have time for is, if not a standby guardianship, what planning tool would you recommend for a client convicted of a criminal offense and going to prison for a few years?
Designation of person-parental relation. Yeah.
Yeah.
Might be tricky. I don't know how difficult it is, and I imagine it wouldn't be necessarily very easy for that person, right, if they're going for a few years to find a notary after the expiration of 12 months. But yeah, that's what I would recommend.
Yeah, I mean, I'm happy to disagree, but I think oftentimes I have clients where one of the parents is incarcerated or facing incarceration, and it's not the primary parent, but in either case, I mean, I think depending on the circumstance of who you're considering who would be the standby guardian, or who you're looking to care for the child or children, could also consider the option of joint custody. Assuming, let's say, there is no other parent and you're the primary parent who's facing incarceration, knowing that you could modify if there were some issues down the line. I know for some parents, it's easier probably to have a parental designation, or they feel more comfortable, but often they know that their children are with, say, the grandmother, so it's less of a concern.
I just quickly, I always thought that there should be, like in the military, there's a military power of attorney, for example, for families. And I always thought there should be something as a more general nature for parents in those situations who don't fit in the standby category. So something to think about.
Maybe one day. Yeah.
Great. All right. Well, Carla, any final thoughts or?
I will just wrap and say this has been really, really informative and helpful. I hope panelists have gained a bit of information. And again, I imagine our panelists are open to any questions you may have. Again, I know this seems pretty niche, but again, we've highlighted how this comes up in various contexts for a range of families. And again, it may involve really what we typically encounter, which is guardianship of the person, of the child. So it's something I think for all caregivers to be mindful of. But thank you everyone for speaking today. Really appreciate it.
Thank you.
Thanks. Take care. Bye-bye.
Thank you.